All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated, veuillez vous asseoir.
C'est bon.
Working now. So I can be heard now. Very well. Good afternoon to everybody. I was saying on behalf of the court and personally and on behalf of my colleagues present here, I would like to express my gratitude. I'm going to ask, before anything else, I will ask the court officer to present the case. Microphone, please.
My apologies. Good afternoon, Madam President. Good afternoon, Your Honors. This is a situation in the Republic of Côte d'Ivoire in the case of the prosecutor versus Laurent Gbagbo and Charles Blé Goudé, sitting today, the 13th of December, for an Article 85 compensation hearing. And for the record, we are in open session.
Merci beaucoup.
Thank you very much. Court officer, I would like to introduce myself. Madame Reine Alapini Gansou, and on my right you have the Honourable Judge Joanna Corner, my colleague, and on my left you have the Honourable Judge Sergio Ulgalzi. And with my colleagues, as was said a moment ago, we make up the chamber under Article 85. So the Article 85 chamber. And since this chamber has been constituted by the presidency, further to an application for compensation of Mr. Blé Goudé, it is the first time that we are in open session. And in this regard, I would like to welcome everyone in the courtroom here and all those who are present. I would also like to extend my regards to everybody following us from the gallery and those who are following us via the internet. I would also like to extend my regards to the representatives of the prosecutor, and we are spoiled today because I can see that the office of the prosecutor is highly represented, and furthermore we also have the highly represented defence team and members of the registry. You are all most welcome. Before I go into the subject of our hearing, I would first of all ask you the representative of Mr. Blé Goudé, the defence team, to be so kind as to do the usual formalities, and after that it will be the turn of the Office of the Prosecutor and then, of course, the other teams to introduce themselves.
Madam President, Your Honours, Dear colleagues of the prosecution and registry, good afternoon. The defense of Mr. Charles Blé Goudé is today before this chamber with, on my left side, Ms. Carrie Knoops-Hamburger. On my right side, Ms. Nina Dijk. On my very left side, Ms. Despoina Eleftheriou. And on my left side, behind Ms. Sarah Pedroso. My name is Geert-Jan Alexander Knoops. I'm counsel for Mr. Blé Goudé, who's present in the courtroom as well, Madam President. And my co-counsel, Mr.
Thank you.
Co-counsel, Mr. Claven Indri. He's following the proceedings from Abidjan, as well as our legal assistant, Ms. Lorient van der Leer, currently in France, following the proceedings also remotely. These were our introductions, Madam President.
Je vous remercie.
Thank you very much, Counsel. Officer of the Prosecutor.
Madam President, Your Honours, great privilege to appear before you in court for the first time as prosecutor. I'm joined by Deputy Prosecutor James Stewart to my left, and behind Associate Appeals Counsel Niveda Thiru. My name is Karim Khan. Thank you.
Très bien, je vous remercie.
Very well, thank you.
Good afternoon, Madam President, Your Honours. Registry today is represented by Vera Wang of the Division of External Operations and myself, Thomas Henket, the Senior Legal Advisor. Thank you.
Merci beaucoup.
Thank you very much. I would like to thank you. So we shall go into the heart of our meeting here today. I was able to say that we are here in this case specifically in response to an application for compensation from Mr. Charles Blé Goudé, who introduced an application for compensation under Article 85 of the Rome Statute. To summarize, on the 15th of January 2019, Mr. Charles Blé Goudé was acquitted by Trial Chamber 1 by the majority of judges. In the case that I indicated a moment ago, and on the 31st of March 2019, the Appeals Chamber followed with the appeals decision, and on the 9th of September 2021, Mr. Charles Blé Goudé introduced to the presidency of the court an application for compensation, and it is in this regard that our chamber was composed, and in its application, Mr. Charles Blé Goudé indicated that on the part of the prosecutor, he had been victim of an unjustified procedure, and it led to a grave and serious judicial error, and as such, he claimed principally the sum of 381,819 million euros, principally 300, and at a subsidiary level, the sum of 300. So, and this is by way of reparations for the harm that he had suffered with regards to Article 95.3 of the Rome Statute, 85.3 Statute. Now, with regards to the chamber, the registry provided in October 2021 certain information on the conditions and the circumstances for addressing Mr. Charles Blé Goudé, and this information was sent to all parties present. Now, in accordance with the order of the chamber present here, the prosecution under Rule 100, it produced a reply to the application under Rule 1741 from November 2021. And in accordance with the rule, in the Rules of Procedure and Evidence, a hearing can be held when the prosecutor or the applicant makes an application, therefore, or at the discretion of the chamber under Rule 17422. So Mr. Blé Goudé formulated such a request, which was not rejected by the prosecutor, and as such, an application was made under his initial application. And we have, as I said a moment ago, received the written submissions from the parties in this regard. So the chamber, as you all know, received written submissions from the parties, and here today I think that we have not a need to reassess the content of those written submissions. If there are more precise matters which you would like the chamber to focus on, we are perfectly available to receive these elements. If not, then you would be so kind as to not go back over the content of your written submissions. I've also understood that the Council of Mr. Blé Goudé has notified us of certain documents in which he wanted, about which he wanted to intervene. I don't know, as things currently are, if these documents are relevant to us with regards to this particular case, but we shall listen to what is to be said to the extent that for each party we have provided for speaking time. In the meantime, I would also like to recall that the Council of Mr. Blé Goudé has proposed that he takes the floor at a given time in our hearing. We therefore have retained the point with regards to the order already given, that the Council of Mr. Blé Goudé takes the floor for 45 minutes. Because he is the applicant, he will take the floor first, and then we shall accord 5 minutes to Mr. Blé Goudé if he wishes to intervene with regards to the observations and comments of his counsel. In the same way, we shall grant 45 minutes to the prosecutor, and here the prosecutor also, if the prosecutor also has the intention of taking some more time with regards to what we grant to Mr. Blé Goudé and his counsel, then the chamber is open to that with a view to equality of arms. That's what I wanted to say first and foremost. The registry as well is also with us today, and they have already given us certain information, but I imagined that they could perhaps provide us with more. As we say in French, who can do the most can do the least. That's what we say in French. So if you have additional information to share with us, we are very much open to that. So that is what I wanted to say to start with. And by way of conclusion, before I start to give you the floor, I would just like to remind you that we are in open session here. However, it does not prevent us, if necessary, from going into private session. And as such, please do not hesitate to express the need to do so if you feel that. Having said that, Maître Knops, I give the floor to you.
Thank you very much, Madam President. May I suggest the chamber that the address of Mr. Blé Goudé of 5 minutes could be scheduled by the Chamber after the prosecution submissions, because I believe that the acquitted person would have the...
Monsieur,
Maître, we have debated at length the procedure before coming here this afternoon, and I think within the case in point, it's the defender who should have the floor lastly. So we've really done our utmost to authorize him to speak after you. And that's the responsibility which we have taken upon ourselves. We cannot violate the rules of procedure in such a way. Thank you.
Thank you, Madam President. I appreciate your comment and the Chamber's authorization that Mr. Blé Goudé can address the Chamber. Thank you so much. Dear members of the Chamber, before I respond to the submissions of the prosecution, a brief introduction. It was almost 6 years ago, Madam President, in this very courtroom, although I was standing on the left side of the courtroom here, that our defense team gave an opening statement in the case of Mr. Blé Goudé. Already then, in the opening statement, we submitted that the prosecution suffered from what we mentioned willful blindness in its prosecution, in its case theory of Mr. Blé Goudé. And I still remember from 6 years ago that I quoted from an impressive book written by Reuven Fenton, author at the New York Post. The book mentioned the stolen years, stories of wrongfully imprisoned persons. And in this book, Madam President, Your Honors, you find an impressive foreword written by the late Reuben Carter, also known as the Hurricane, in which Mr. Denzel Washington later featured in the movie, which was based on his life story. Unfortunately, Reuben Carter passed away on the 20th April 2014, and he was wrongfully convicted initially for 3 murders, serving a life sentence before he was exonerated after 2 decades in 1985. And in my opening statement 6 years ago, I quoted the following words, and these words are now even more topical. Reuben Carter wrote in this foreword, "My view is that the real cause of wrongful convictions is willful blindness. And that's something most defendants never imagine is possible." End of quotation. Now, of course, Mr. President, Madam President, Your Honors, we all know that Mr. Blé Goudé was acquitted. Acquitted at first instance before the defense was even requested to present its case. So wasn't justice served in this case? Wasn't his story the opposite of Reuben Carter's narrative? Our answer is no. No, Your Honors, while the judges of Trial Chamber 1 and the Appeals Chamber who confirmed Mr. Blé Goudé's acquittal saw the truth, the prosecution did not. Prosecution pursued this case on the basis of a pre-constructed narrative. And despite years, exactly 9 years of investigation in a country which was more favorable to its cause, and years of presenting evidence that did not confirm this narrative in the slightest, the prosecution never took stock of the situation, never did try to see objectively the case before it. and see that Mr. Blé Goudé, that his case should never have come before this court, due to willful blindness. Due to willful blindness, the prosecution never was willing to admit, and still not willing to admit, the truth. That it had, in the words of Judge Henderson, put the cart before the horse. And that it started from the premise that, as Judge Henderson put it in paragraph 79 of his reasons, the premise that its case theory is the correct one. And we all know the consequences of this willful blindness. The consequences were disastrous. Almost 5 years, 1,778 days, Mr. Blé Goudé spent of his life in prison, right here in the city of The Hague. And to this day, Madam President, he is not free. He is far from free. Can we say that the trial chamber's decision to acquit, therefore, however early it came, remedied the years of suffering endured by Mr. Blé Goudé as a result of the prosecution blindness? Our answer is resounding: no, Your Honours. That's why we're here before you today. We know that the threshold to satisfy the requirements of Article 85(3) is high, as highlighted correctly by the prosecution in its response. But, Madam President, Your Honours, if Charles Blé Goudé's case does not fit within the raison d'être of Article 85, which case does? Which case does, Your Honours? That's a key question. We're also mindful of the compensation request and decision in Bemba, where the pre-trial chamber too rejected Mr. Bemba's request for compensation. However, it acknowledged in paragraph 69 that 10 years, in the case of Bemba, is a significant amount of time to spend in custody. And it would likely result in personal suffering, which would trigger compensation in many national systems for violation of fundamental fair trial rights. Whilst the statutory constraints, as illustrated in its decision, are such as to make it impossible for the Chamber to compensate this, the Chamber finds it urgent for the state parties to embark on a review of the statute, so as to consider addressing these limitations. Madam President, it's the end of the quotation of the judges in the Bemba pre-trial chamber 2, paragraph 69. Madam President, Your Honours, the reality is that state parties did not reform the statute, even during the latest session. However, the defense submits that this chamber's hands are not tied like the chamber's hands were in Bemba. You're not tied to the apparent limitation of the statute. If it's the court's aim to serve as a beacon at the forefront of all matters pertaining to individual human rights, as the chamber found in Bemba, in the Bemba's compensation decision, then we submit to this chamber, Madam President, that this chamber could apply what we call a teleological interpretation of Article 85(3), meaning that it's completely within the spirit, the object and purpose of the drafters of Article 85(3) to grant Mr. Blé Goudé's request. And, Your Honours, again, if the drafters had one case in mind to subsume under Article 85(3), it is the case of Charles Blé Goudé. There was no case to answer. That was the ultimate verdict, upheld in appeal. No case to answer. And such an interpretation, a teleological interpretation of the statute, is also in accordance with Article 31 of the Vienna Convention on the Law of Treaties, which obliges the international community to interpreted the statute within its spirit, object and purpose. Now, we will outline for this chamber why we think this is the case, why this chamber should have the courage to do what the state parties didn't do, apply a teleological interpretation of Article 85. First, we'll argue that the circumstances of this case do fall within the scope of 85. And the prosecution submits that we, as defense, just took a few remarks from the trial chamber's judgment and are trying to relitigate trial issues. But, Your Honours, the contrary is true. What the prosecution characterizes as merely remarks are specific references, legal findings of the judges, which show that the conditions for a grave and manifest miscarriage of justice in terms of a wrongful prosecution is satisfied. It's the prosecution in turn, in its response to reopens the litigation, going so far as to suggest what the judges in the majority really meant. Whereas the litigation on the merits of this case was closed when the appeals chamber rendered its judgment confirming Mr. Blé Goudé's acquittal. Litis finiri oportet, the Latin maximum saying litigation must be concluded at some point in time. Secondly, the part of our submissions which deal with the content of the prosecution request will focus on rectifying some of the prosecution submissions with respect to its narrative, investigation, and the quality of evidence. And we maintain our position, Madam President, that an appeal of an acquittal in which the prosecution cannot even definitely state whether it can retrial an acquitted person is a frivolous appeal. After 9 years of investigation, mind you. Now, let us first look at the scope of 85.3. Prosecution submits that we failed as defense to meet the strict requirements of 85.3. Our response, Madam President, Your Honours. Of course, we are aware that the statute does not provide an automatic right to compensation for acquitted persons. But this is not our argument. Our argument is that Mr. Blé Goudé was victim of a wrongful prosecution in that the prosecution did not exercise due diligence when it turned a blind eye to the weakness of its case during the 9 years investigation and subsequent prosecution and appeal in the case. And we all know what constitutes a wrongful prosecution. It has been defined by this court and both the chambers in Unjolo and Bemba explicitly listed wrongful prosecution as an example of a manifest and grave miscarriage of justice, without specifying what such a prosecution might entail. We agree with the prosecution's submission that Article 85.3 does not require a showing of malefides. The requirement of malefides was explicitly excluded during the drafting history of 85.3. We are mindful of this, but this is not our argument. It means that a wrongful prosecution does not require malice on the part of the prosecution and should not be conflated with the tort or malicious prosecution found in common law systems. It is not the position of the defense that the prosecution acted with malice or ill intent. Therefore, the prosecution submissions stating that we, defense, disregarded Judge Henderson's reasonings in which he held that any criticism did not impugn the integrity or good faith and commitment of the women and men who represented the prosecution in this case, all those submissions are not relevant because we are not submitting this. It's our position that there was a systemic failure deliver justice in this case, which was not caused by the ill will of any individual affiliated with the prosecution, but rather it's the institution of the prosecution who, lacking due diligence, never objectively assessed the quality of the evidence it had gathered and whether this evidence confirmed its case theory regarding Mr. Charles Blé Goudé, which accordingly constituted a wrongful prosecution. Madam President, Your Honours, the exceptional weakness of the evidence the prosecution gathered should have raised red flags for the prosecution office early in its investigation, especially in the context of the situation of Côte d'Ivoire, a country where the prosecution could not find a more favorable country to investigate those 9 years in, given it was headed by the political opponents of Mr. Charles Blé Goudé and Mr. Gbagbo. However, the prosecution never discontinued its case. Throughout the proceedings, the prosecution perceived the criminal prosecution of Charles Blé Goudé as a sporting match, to employ a term used by the Appeals Council at the appellate hearing on the 20 June 2020, transcript number 238 at page 21. A sporting match that needed to win, and it needed just to get through all the procedural hoops to make it happen, to first get an arrest warrant, then the confirmation decision, and then next to conquer the no case to answer motion. However, and that's the issue, at no point in time it objectively considered whether it would have gathered sufficient probative evidence to prove Mr. Blé Goudé's guilt beyond reasonable doubt. Even on appeal, Madam President, the prosecution could not state whether it would be able to retry Mr. Blé Goudé and prove his guilt. Nor did the prosecution ever try to show on appeal, advancing just 2 procedural alleged errors in appeal, nothing on the merits. It did not ever try to show that any reasonable trial chamber would have convicted Mr. Charles Blé Goudé, as deplored by the presiding judge of the appeals chamber, the Honorable Judge Ebu Usuji, in his separate concurring opinion on paragraph 13. Your Honours, this is definitely a situation where Article 85(3) should apply. While the prosecution emphasizes the very strict requirements of 85(3), it's important to stress the raison d'être of this provision. In the Bemba, the court found the existence of this provision to be, I quote from that decision, "It is grounded in the belief that there is an inherent unfairness when an innocent person has spent time in prison and that some form of reparation is due as a matter of fundamental justice." And the pretrial chamber 2 in the Bemba case further emphasized that Article 85(3) marks a step forward as regards the scope of rights pertaining to those having been adversely affected by the operation of international criminal law and tribunals. In the words of one scholar, quoted by the Bemba decision, it is the most advanced text in terms of protection of rights of compensation, even compared to the provisions of the International Convention on Human Rights. I hope these words, Madam President, can be realized in this case. Your Honours, the Chamber in appeal unequivocally found that both Judge Henderson and Judge Tafuser, I quote, shared the view that the evidence was exceptionally weak and that the fundamental flaw of the prosecution case lay in the numerous divergencies between the prosecution's one-sided narrative and the facts emerging from her own evidence, unquote. And you find this in paragraph 328, also in the appeals judgment. Moreover, the appeals chamber emphasized that the prosecution arguments, merely based on two just procedural appeal grounds, not on the merits, if accepted, did not demonstrate, according to the majority of the appeals chamber, that the trial chamber would not have acquitted Mr. Blé Goudé had it not made the alleged errors on appeal. Paragraph 374 of the appeals judgment. Your Honours, this says it all about a wrongful prosecution. Prosecution submits that the defense inappropriately places an obligation of result on the prosecution. But even this is not our case, Your Honours. This was not a typical case of just weak evidence that resulted in this early acquittal. This was a case where the appeals chamber emphasized that the trial chamber found the evidence to be exceptionally weak, and one where both judges in the majority were critical on the prosecution's case, also accepted by the appeals chamber in paragraph 267. This was also an appeal where the prosecution made no arguments on the merits of an absence of an alleged link between Mr. Blé Goudé and the crimes charged, as observed by the appeals judges in the majority in paragraph 374. Therefore, Madam President, unlike the Bemba compensation decision, where there were no circumstances of such gravity as to make it plausible or necessary to consider that such a miscarriage of justice might have indeed occurred, here, in the case of Charles Blé Goudé, these circumstances do exist, derived from both trial chamber and appeals judgments. What the prosecution refers to as being merely remarks by Judge Henderson and Judge Tafusser, Madam President, these are specific references and legal findings from an Article 74 trial judgment. That was notably confirmed on appeal. Now, res judicata, which show definitely that Article 85.3 was met. The fact that Judge Carbuccia descended from the majority, or that two judges descended from the appeals judgment, is irrelevant and impermissible to rely on in this compensation procedure under the jurisprudence of the European Court of Human Rights. It would amount to a violation of the presumption of innocence, as enshrined in Article 6, Section 2 of the European Convention on Human Rights, if in a compensation procedure one would rely on dissenting opinions. In the case of Sekanina versus Austria, the European Court of Human Rights, in its judgment of 25 August 1993, paragraph 30, ruled in this regard the following. I quote from that judgment. The voicing of suspicions regarding an accused's innocence is conceivable as long as the conclusion of the criminal proceedings has not resulted in a decision on the merits of the accusation. However, it's no longer admissible to rely on such suspicions once an acquittal has become final. Even the mere suggestion, end of quote, even the mere suggestion, Madam President, of guilt is impermissible to rely on after an acquittal has become final, under the same jurisprudence of the European Court. I refer to the judgment of 11th February 2003 in the case of O versus Norway, paragraph 39, where the judges of the European Court held that even the mere inference to guilt is in this regard, when it concerns the education of a compensation request after acquittal, impermissible. Mind you, Madam President, Your Honours, that the Sekanina case I just mentioned is especially instructive in these proceedings of Charles Blé Goudé, since Austria does not provide an automatic right to compensation to acquitted persons, like Article 85.3. And therefore its provisions resemble Article 85.3. Therefore any reference to the dissenting opinions in this case should be disregarded and be seen as a reversal of the burden of proof, effectively making Charles Blé Goudé to prove again that he is innocent. Madam President, moreover, the prosecution reliance on the confirmation decision in this case, in which all three judges confirmed the charges, we all know this, blatantly ignores the defense's submission on this very point. I refer, Your Honours, to paragraph 12 for our request. The prosecution never responded in this regard to our argument, which was the following. Yes, Pre-trial Chamber 2 did confirm the charges, but it did so under the assumption, Madam President, under the assumption that the prosecution would at trial present evidence capable of proving guilt beyond a reasonable doubt. That was the assumption of the confirmation decision. At that time, the judges of the confirmation chamber had no clue about what happened during trial. The prosecution never assessed whether its narrative would hold up in court, and even tried to beat the defense at the no case to answer stage by requesting the chamber to provide guidance on the test that would apply to the no case to answer motion. The prosecution should not have treated this case as a sportive game. As the appeals chamber put it in paragraph 347, Madam President, I quote, "The prosecution was and is at all times aware that she is required to prove her case beyond a reasonable doubt with credible evidence." End of quote. These words were written not without reason by the majority. Therefore, why did the prosecution not adjust its narrative so as to reflect the reality of the Côte d'Ivoire situation and Mr. Blé Goudé's alleged role? The prosecution never provided the chamber with any answer to this question. Your Honours, Mr. Blé Goudé was held in prison for nearly 5 years, and even after his acquittal, he remains subject to restrictions on his liberty rights and continues to suffer from them to this very day, nearly 8 years after he was brought to the seat of this court. Does therefore this acquittal remedy the harm he has suffered? No. Your Honours have read it in the request. So many years in prison necessarily causes much human suffering and could have been completely avoided had the prosecution acted diligently and dropped the case in its early stages. As recalled by the Bemba pre-trial chamber, the right to an effective remedy undoubtedly forms part of customary international law. It recalled the Ramakuba ICTR case, where the chamber found, and you can find it in paragraph 50 of the Bemba compensation decision, I quote, "Its inherent power to give effect to an accused or former accused right to an effective remedy encompasses the power to grant financial compensation where, in the specific circumstances of the case, it constitutes the appropriate remedy to redress a violation of human rights in question." End of quote. Madam President, Your Honours, granting Mr. Blé Goudé's Article 85.2.3 request does constitute in this situation a proper remedy to redress the violation of his right to liberty and a right to a speedy trial. Unlike the Rwanda Tribunal statute, the ICTR statute, where there is no provision to be found governing compensation of acquitted persons, the ICC, as we know, has such a provision. And while we do not submit that the prosecution acted maliciously, it undoubtedly showed a complete disregard for Mr. Blé Goudé's rights to liberty, producing a one-sided narrative that never squared with his own evidence as observed by Judge Henderson and Judge Tafousser. This concludes the submissions on the scope and the applicability of 85.3, and now we briefly address some of the specific submissions of the prosecution written arguments. First, the prosecution alleges that it has met its 54 obligations in that it had collected a substantial body of evidence, whether documentary or testimonial, including exonerating information. Our answer, Madam President, this is an irrelevant argument for these proceedings.
Could you, I'm sorry to interrupt, Mr. Knops, could you refer us to the paragraphs of the prosecution's response when you're dealing with them?
I'm happy to do so, Madam Coroner. The first argument, substantial body of evidence, prosecution says we have met our 54 Section 1A obligations in that we collected a substantial body of evidence. Is to be found in the prosecution written submissions paragraph 17 till 21. Our answer, this might be, but it's not relevant for and not decisive for the case at hand. The prosecution is not discharged of its investigative obligations under 54 by merely collecting and disclosing incriminating and exonerating evidence, however voluminous it might be, and by applying a certain methodology, as the prosecution suggests, and that's to be found in paragraph 17 of its response. No, Madam President, Your Honours, the prosecution has also an obligation to extend its investigation to all aspects of the case, but of course only to the extent that such evidence contributes to the assessment of whether there is a matter of criminal responsibility or not. So that once the prosecution determines to proceed with its case, the relevant chamber and parties can get a clear indication that the case has substance and are able to assess holistically the evidence. It is this holistic assessment that the defense, as we submit, was not appropriately completed by the prosecution. The prosecution lacked due diligence in refusing in two ways. First, to attach the required significance to the weak, exceptional weak, contradictory and exonerating evidence it had collected, and more generally, second, draw the obvious conclusions from the evidence, which the trial chamber ultimately did in its no case to answer judgment, namely, that its case theory was flawed. As pointed out by Judge Henderson in his reasons, and you can find it in paragraph 90 of Judge Henderson's reasons, I quote, "The prosecution should not be allowed to hide behind large volumes of submitted evidence and an indeterminate system of evidence to avoid scrutiny of her case." End of quote. Madam President, we never alleged that the evidence was withheld, that any evidence was withheld, as the prosecution mistakenly advances in its response in paragraph 24. We allege that the evaluation of the information collected, however considerable and complex it was, should have led the prosecution to conclude, in light of its duty to establish the truth, that the office would never be able to show guilt beyond a reasonable doubt under Article 66 of the statute. In light of this, the fact that the prosecution sought to interview Mr. Blé Goudé regarding the allegations against him is also with all due respect, totally not relevant. Apart from the suspect having the right to remain silent, we presented in detail in our opening statement the views of Charles Blé Goudé, which reflected also his own statement. With respect to the narrative of the prosecution, Judge Henderson did acknowledge that the prosecution case was prima facie plausible. Indeed, you can find it in the prosecution response paragraph 25. Indeed, that was the observation of Judge Henderson in the majority reasons. But Judge Henderson said something different in addition to that. In his preliminary statement, he emphasized that upon scrutiny, the prosecution systematically omitted or downplayed significant factual elements which resulted in a highly misleading and somewhat skewed version of the events, which did not reflect the reality of the case. Paragraph 66 of Judge Henderson's reasons. It was not merely a difference of interpretation, Your Honours, of the evidence between defense and prosecution, as the prosecution suggests. No. Rather, there was a fundamental divergence between the prosecution's one-sided narrative and the facts emerging from its own evidence, as observed by Judge Henderson's reasons in paragraph 1 and 2038, and in Judge Tafous's opinion in the paragraphs 68, 74, and 12. It was actually on the basis of this fundamental flaw of the prosecution case that the trial chamber 1 dismissed the case halfway through the proceedings. It's important to emphasize to this chamber, Madam President, that the appeals chamber affirmed that both judges in the majority believed that the prosecution's one-sided narrative was manifestly unsupported by the evidence. Paragraph 340 of the appeals judgment and paragraph 317 and paragraph 328 till 330 of the appeals majority judgment, Madam President. The majority in the appeals chamber also accepted that the prosecution evidence against the appellant, Mr. Charles Blé Goudé, was to be qualified not only weak, but exceptionally weak. And this exceptionally weakness was of great significance, as the majority ruled, when applying any test of sufficiency, paragraph 340 of the appeals judgment. Judge Scarbuccia's dissent is therefore not relevant to rely on as a matter of res judicata. The prosecution argument on documentary evidence and receipts is also not relevant. Defense in its request was not merely disagreeing with the prosecution exercise of its discretion in the presentation of its evidence. Now, we highlighted the implausibility of the prosecution narrative when faced with the lack of evidence to support it. And secondly, its failure to comply with its obligation to genuinely search for the truth by omitting to progressively adjust its narrative to the insufficient evidence presented at trial. Prosecution further alleges that we impermissibly re-litigate the trial issues again, such as the authenticity of documents and the use of anonymous hearsay. And that's to be found in the response paragraph 5 and 30. Your Honours, this is far from the truth. To the contrary, we are not asking this chamber to reassess whether the prosecution failed to establish the authenticity of documents. The reason why we are not asking this is that these are matters of res judicata. The prosecution is, to the contrary, reopening the debate, requesting this chamber to look back in the evidence, says to assess how certain witnesses authenticated documents, etc. We, on the other hand, are simply asking this chamber to take the conclusive findings of the trial chamber and the appeals chamber into consideration in the context of this request. It's therefore also completely irrelevant that the prosecution provided the chamber with investigation reports or that it tried to establish the authenticity of some documents at trial, as it's suggested in its response paragraphs 32 and 33. The prosecution is part of the judicial system and is a gatekeeper within that system. And in this vein, these arguments therefore cannot foreclose this chamber for accepting the acquittal. Here it's also totally irrelevant that Judge Henderson's view that the authenticity of signatures could not be taken for granted might have been based on one insider witness, as the prosecution suggests in its response paragraph 34. Judge Henderson identified not just one discrete problem affecting the documents, but he identified pervasive authenticity problems affecting a considerable number of documents in its reasons paragraph 36. In his view, I quote, a majority of documents exhibits that were submitted by the prosecution would not pass even the most rudimentary admissibility test in many domestic systems, paragraph 36 of his reasons. And in the same paragraph, Judge Henderson does say that this is especially true in a case like here, where much of the evidence was essentially provided by the current government, which was headed by political opponents of the accused. Indeed, under these circumstances, as Judge Henderson mentions, the chamber would have expected the prosecution to take further steps to ensure that important documentary evidence was properly and demonstrably authenticated before being submitted to the court. Now, regarding the judge's conclusions of the trial chamber 1 on the inappropriate use of anonymous hearsay during the proceedings, we didn't mischaracterize Judge Henderson's findings. He did seriously question and criticize the prosecution's choice of using anonymous evidence, anonymous hearsay evidence, on such a considerable proportion of evidence that he explained that this so-called relaxed approach, to be found in paragraph 43 of his reasons, had a direct and very impact consequence for the case, because it made the chamber impossible to ascribe any probative value to the evidence in question. Judge Henderson gave countless examples, Madam President, throughout his reasonings of evidence based on anonymous hearsay, which was either uncorroborated or corroborated just by hearsay and could therefore not be relied on. The prosecution failed to act appropriately in refusing to attach more significance to the very problematic fact that its case was based largely on hearsay and anonymous hearsay. For sure, this should have put the prosecution on notice that its case was too weak to sustain a conviction. And you find the countless examples of Judge Henderson's observations in the paragraphs 608, 622, 653, 665, 713, 749, 909, and 915, etc. Madam President, the prosecution also overlooks the fact that the
Maître,
Counsel,
vous êtes en train de prendre sur le temps de parole
you are
qui vont vous suivre.
eating into the
Vous avez déjà
speaking time.
parlé du 45
of those who will follow you. You have already been speaking for more than 45 minutes, so can you kindly speed up or summarize?
Thank you, Madam President. The observations by the
Allez-y.
Please go ahead. Please go ahead, I can see. I can see certain people from your team who are nodding their heads, but I think that you have already used up the 45 minutes, but you can go ahead by way of summary.
Thank you, Madam President. Thank you so much. I would like to point, Madam President, that in the judgment of the Trial Chamber 1, the judges acknowledged that indeed the prosecution narrative was confined to one narrative and not two. And I refer the chamber to the second order of the Trial Chamber of 8 June 2018, where the judges unanimously, including Judge Carpuccia, noted that notwithstanding some minor changes in respect of a limited number of allegations, the overall narrative of the trial brief, which was ordered by the chamber, remained essentially the same as the one mirrored in the pre-trial brief. It's therefore not correct to state that the changes which were apparently ordered by the chamber related just to corrections and footnotes. The chamber clearly ordered the prosecution to review its case and in its second order observed that despite the filing of the trial brief, the theory of the prosecution effectively did not change. Second point is that the order, procedure order, is quite important in this case. The prosecution only during the NCTA proceedings, no case to aunt proceedings, was willing to withdraw some of the charges. While in, and that was in September 2018, while the chamber in its order, and that was the order which the chamber gave in March, asked the prosecution to file a trial brief and reframe its narrative by taking into consideration the testimonies heard and the documentary evidence submitted at trial. That's to be found in paragraph 10 of the first trial brief order. Notwithstanding this order, the prosecution continued with its narrative, and only after the NCTA motion was introduced by the defense, the prosecution was willing to amend, in a way, the charges by dropping two charges, the third and the fourth incident. And therefore, also this is a clear example that the prosecution was staying on to its theory as long as possible. Finally, Madam President, the appeals proceedings, very briefly to illustrate that indeed there was a one-sided narrative and never a two-sided narrative. You will find in the appeals proceedings that the prosecution was not in the position to inform the chamber whether it was willing and able to retry its case. The dissenting, even the two dissenting judges, Judge Ibanez and Judge Bossa, observed in their dissenting opinions that it remained unclear throughout the appellate proceedings what precisely the prosecution considered the procedural effect of such a declaration of a mistrial would be. It was the initial request in appeal, a mistrial, but even the dissenting judges observed that the mistrial cannot be part and parcel of an appeal proceedings before the ICC proceedings. The prosecution's unclear position regarding the relief sought was also made apparent during the appeals hearing on the 26th of June 2020, where the prosecution clarified that they were not asking the appeals chamber to directly order a retrial. Rather, the chamber is free to do so, the appeals chamber, should they consider this to be the correct remedy. A few minutes later, at the same hearing, the counsel for the prosecution stated that now to confirm the prosecution's present intention is to hold retrial should her appeal succeed. You can find this in the transcript, page number 240, page 28, lines 15 till 18.
Maître,
Therefore,
vous prenez sur le temps.
Counsel, you're taking up the speaking time of your client. You are currently taking your client's speaking time. And that of the defender as well.
Madam President, is it my understanding that the speaking time for Mr. Blé Goudé is in addition to the speaking time we were granted? I'm aware that I've taken more time than if that's the case, I will conclude. And
C'est exactement ce que nous avons.
That's exactly what we said at the start when you were presenting the case. We gave you 45 minutes, and at your request, and at the request of Mr. Blé Goudé, we also accorded 5 minutes to him. So in a general way, on your side, you've have 50 minutes in total.
in that regard, Madam President, I will conclude. And I would invite, finally, Madam President, the Chamber to acknowledge that the raison d'être of Article 85 is met, and if this would be acknowledged by your Chamber, by granting this request, it would make Article 85 not redundant, not an empty shell. And it would encourage the institution of the prosecution not to continue to bring exceptional weak cases to this chamber. Thank you.
Mr. Knops, before you sit down, I have a question which will not deduct from your
Monsieur
client's...
Knox, il y a la
Mr. Knox, there is the judge who would like to put a question to you before continuing.
Thank you, Madam President. Sorry, I started before you'd spoken. Mr. Knops, I just have one question for you. In the course of what could be said to be highly emotional, not to say emotive, language used in your application for compensation from about paragraphs 25 onwards, you divide the periods for which you request compensation into 3. And effectively, it's not so clear from the redacted public version, but you are saying that there is a second period which begins from the 1st of February 2019 until the 31st of March 2021. And you've repeated that even though he's been released with conditions, he's still not free. And that is the basis of your application, is it not, for compensation for these periods? And what I'd simply like to know is this. Mm-hmm. Do you not consider that by failing to mention in your application, or indeed at any stage during your oral submissions, that effectively your client cannot go back to the Côte d'Ivoire, because if he does, he's going to be serving 20 years imprisonment, passed in, I understand it, December 2019, you could be said to be misleading the court, if by omission, if nothing else?
I understand your question, Madam Corner. First of all, it's a very intriguing question. First of all, Mr. Blé Goudé, of course, didn't waive his right to liberty, as the prosecution suggests, by accepting the restrictions for house arrest. I think the court is well aware, it's my first observation, with the decision of Bujadje versus Moldova in the European Court of Human Rights Court, where this exactly was the same problem. The defendant agreeing, conceding to conditions of house arrest, but had no choice. And the European Court said this is a matter of duress. So the fact that Mr. Blé Goudé, first of all, did accept the conditions here by the trial chamber and the appeals chamber, that's of course something important. Your question is, did he...
Directed to you, Mr. Knops, not to your client. My question is, do you not think that you should have mentioned in your application for compensation, particularly for that period, that one of the reasons that your client cannot go back to the Côte d'Ivoire, or presumably does not wish to go back to the Côte d'Ivoire, is because he's been sentenced to 20 years in his absence? And therefore, remaining in Holland is probably a positive plus.
Now I understand your question, Ms. Corner. Thank you.
Merci.
Thank you. Thank you, Judge. Now, I think that the Chamber has discussed this question. We have already ruled on this. Even if Mr. Knops is not able to give us a satisfactory response, but this is a point which we will come to at the appropriate time. We will give notification on this.
I think Mr. Knops, just in one sentence, really it is either yes or no. You don't consider it, or you do consider it to be misleading?
No, Honourable Judge Corner, I don't think it's misleading, bearing in mind that Mr. Blé Goudé does want to go back, because the trial, with all due respect, in Côte d'Ivoire, we don't have the time to go in it, was a farce. And he can receive a retrial. So he is adamant to go back. So it's not a positive thing that he can remain for now in the Netherlands. Thank you so much.
L'honorable juge...
Honourable Judge, you don't wish to? No? In which case, have you finished, counsel? Have you concluded, counsel? Have you concluded?
Yes, Madam President, thank you.
Okay.
Very well. So your client can therefore have the 5 minutes accorded to him.
Pourrions-nous accorder les 5 minutes à votre client?
So should we accord the 5 minutes to your client?
Vous avez déjà tout dit en...
Or have you said everything in his stead?
I think, Madam President, it would be instructive for the Chamber to listen 5 minutes to Mr. Blé Goudé because of the personal address.
Exactement.
Exactly. That's what we thought. But I wanted to have exchanges in the right procedure, and we cannot go beyond the 5 allocated minutes.
La parole.
He has the floor.
Vous avez 5 minutes, s'il vous plaît.
You have 5 minutes. Thank you. I'm just waiting for the lecture to be provided to me.
Vous avez la parole.
You have the floor. Honourable judges, ladies and gentlemen of the court, I am Charles Blé Goudé. I greet you with deference. I'm native of Gbagbo from Côte d'Ivoire, and Africa is my continent. Law is my backbone. Honourable judges, as for myself, I do not know the judges who acquitted me at trial, just as I also do not know those who definitively confirmed my acquittal in appeal. Only law has taken me out of prison, and it is to this law that I would like to have recourse to this afternoon to ask for reparations. And why? After 8 years, 8 years of my life, which was eaten up, it was taken from me. I didn't say 8 days. I didn't say 8 weeks. I didn't say 8 months. I am speaking of 8 long years of deprivation, of desocialization. 8 years that I was presented to everyone as a criminal. 8 years of trauma. Your Honours, as you know, I was arrested in Ghana without even being presented to a lawyer. I was in Côte d'Ivoire to execute the arrest warrant. I was detained for 14 months without seeing the day. In execution of the arrest warrant of the ICC, I was transferred in 2004 in execution of the arrest warrant, and for 6 years I was subject to proceedings here. There was the work of my lawyer, and thanks to that I was acquitted. But during all these years, you can imagine, madam, honourable judges, that my children had to flee. They had to flee the view of their classmates at school. They were the children of a criminal. They grew up without their father. And they had to say, "Mummy, why isn't our father there?" Because he was never there. Because he could not be there. Your Honours, that was a difficult moment for me and my family. And when I was acquitted, I was happy. Because for me, it was the end of this Calvary. But I made a major mistake. The Calvary continues, and it continues to this very day. While the ICC had the authority and power through cooperation with Côte d'Ivoire, cooperation in the name of which there was special aeroplane was made available to travel without a passport or visa. But since my acquittal, the ICC has not carried out the clause of cooperation other than at a formal level by providing me with a passport. A passport that I'm waiting for. And I have been waiting it for 11 months, 6 to obtain a meeting. And now I'm awaiting still my passport. That is to say that I am currently losing my Ivorian citizenship. And Blé Goudé has become an expatriate. But if the ICC can arrest somebody, can transfer somebody, can transport somebody, can try and convict somebody as being guilty, then it can also free somebody. It can rehabilitate somebody. It can re-establish their lives. Your Honours, that is what I would like to put to you. Not necessarily to ask for money, because the harm that I have suffered represents far more than money. It is my dignity, my image. That has been destroyed. Question. Mr. Blé Goudé, could you conclude? Madam Judge, can you hear me, Mr. Blé Goudé? Yes, I can hear you. This is taking time. And do you trust your counsel? Indeed. I'm going to conclude, therefore, Madam Judge, to say that here in Holland, what my counsel hasn't said, I can't even have access to public services. Even the vaccine, the COVID vaccine, for which everybody is encouraged to take. Madam, I cannot even have access to that vaccine. I am before you, and I ask for reparations and compensation for all that. And I believe you have the power, you have the authority to take me to Côte d'Ivoire in a safe place, as was indicated by the appeals chamber, such that I can rebuild my life, rebuild myself, and take up my activities again and enjoy my normal family life. Because I was acquitted, the trial in Côte d'Ivoire was not a proper trial. I was tried on the same facts. I have said it, and I would like to thank you.
Merci beaucoup.
Thank you very much. We take good note that your question is not above all about money, but about dignity. Indeed. And that goes, the moral reparations go along with financial reparations as well. Very well. It's interesting to hear you say that, because I thought that your question wasn't a financial one, but a question of dignity. But thank you for that. Thank you. Thank you. You're welcome, madam. Can I give the floor? Can I give the floor to the prosecutor? You have the floor, prosecutor. You have 45 minutes.
Madam President, Your Honours, I'm most grateful, and bearing in mind the injunction at the outset, I don't intend to repeat what's in the response. I think that sets out, with the greatest of respect, quite comprehensively, the proper answer as to why the prosecution say the application of Mr. Blé Goudé should be dismissed. From what my learned friend has said today and what Mr. Blé Goudé has stated, it's clear that he's pleased to be acquitted, but unhappy to have been charged, arrested, and detained. I can understand that. It's natural. But that's legally irrelevant as a consideration as to the applicability of Article 85(3). This is a judgment, of course, that was strident in part in its language in areas of criticism regarding the office. Stinging criticism in part as well, I fully concede. Could the office of the prosecutor have done better? Of course, we can always do better. But that, similarly, is not the question. That similarly does not bring an unmeritorious case within the confines of Article 85(3). And the difficulty perhaps that my learned friend is grappling with is evidenced by his opening submission, praying in aid a teleological approach, emotively asking Your Honours to be courageous, as if Your Honours need any encouragement to do that, but courageous by doing that precisely that which the Assembly of State Parties have declined to do. On the one hand, my learned friend says that the Rome Statute regime is the most advanced text in terms of compensation. I can agree with that. But again, Article 85(3), as the Bemba jurisprudence and the Jolo jurisprudence make clear, sets out very deliberately a high threshold. It is of discretionary nature, but the high threshold simply has not been made out in this particular case. My learned friend, Mr. James Stewart, will do go into some more detail, but perhaps I can just very briefly address a few points. The first is the very notable feature of this case, that 5 judges, indeed 6 judges, of this International Criminal Court either confirmed the case, or in terms of the 3 judges at confirmation, at least in part, 2 judges completely on all counts, Judge Christine Weingart in relation to 3 of the incidents. Judge Karbucha dissented, and 2 judges, of course, at the appellate level would have remitted the case back to retrial. Now, I simply don't concede for a moment that my learned friend's contortion in my submission of res judicata is appropriate. And I would ask you to look at the 2 European court cases that my learned friend has prayed in aid, Owen, Norway, and Sakanina and Austria. This is not a case in which there is a smell of suspicion that is being cast upon somebody who's been declared not guilty. This is a case in which my learned friend, who has the burden of proof, has to establish grave and manifest miscarriage of justice has taken place. And to establish that conclusively, how is it other than extremely relevant to the appropriateness of the warrant being issued or the case being confirmed that judges at different stages in issuing a warrant, in confirming the case, in dissenting, and in 2 judges that would have remitted the case back, were of a mind that the evidence disclosed something that required an answer. The fact that those judges spoke in the manner that they did is relevant to whether or not there's been a miscarriage of justice. In other words, whether or not this is a prosecution that should never have been brought. Your Honour, my learned friend largely glosses over those 6 judges. And he says, in terms of respect to Judge Karbucha, that her dissent was irrelevant, inconvenient, perhaps, irrelevant, not a bit of it. Your Honour, those requirements of Article 85.3, exceptional circumstances, conclusive facts, and a grave and manifest miscarriage of justice cannot be airbrushed out by my learned friend with the litany of complaints and grievances that he has put forward in his submissions and in today. The conjecture that is a feature of the written submissions and again today, for example, the assumptions as to what the judges of the pre-trial chamber were doing when they were issuing their confirmation decision, is similarly revealing, because it is a conclusion that counsel does not pray in aid any authority in support of that proposition. The judges were rather restricted to the requirements of the statute and whether or not the case should be confirmed. So again, when one looks at the conjecture, the views as to why things were done, one needs to do so with a lens of some circumspection in my respectful submission. Your Honours, I don't intend to go into more detail. The fact that 2 judges would have remitted the matter back for a retrial, the fact that 1 judge dissented, the fact that 3 judges confirmed the case, the fact that an arrest warrant was properly issued on the prosecution's application is not sufficient to give rise to complaint, nor is the acquittal at the end of the day. Indeed, if anything, my learned friend, one would have expected perhaps a degree of commendation of the trial chamber in engineering in a procedural safeguard that, as compared with Mr. Bemba or Mr. Najolo, he was not required to put on a defence. However one looks at it, from whatever vantage point one reviews this case, there has not been a miscarriage of justice. My learned friend has failed to discharge his burden of proof as required by the statute, and for that reason we say the claimant's application should be dismissed. But perhaps, with your leave, Mr. James Stewart will go into further detail on these issues.
Je vous remercie, Monsieur le procureur.
Thank you, Mr. Prosecutor. Mr. Stewart, you have the floor.
We're all making the same mistake. Thank you. Madam President, Your Honours, I'm going to expand very briefly on what the prosecutor has submitted to you. And just to pick up on one aspect of Mr. Knoop's submissions to you, I think you're well aware that we are not challenging the outcome in this case. We've acknowledged the outcome and accepted it with deference and respect in paragraph 9 of our response. So that's not the issue for us. The question before the Chamber today, as the prosecutor has outlined, is whether exceptional circumstances exist in Mr. Blé Goudé's case where the Chamber could find conclusive facts that he has been the victim of a grave and manifest miscarriage of justice. And of course, our submission is that the answer must be no. The standard under Article 85.3, as the prosecutor has outlined, is a high one. Mr. Knoop has acknowledged that we're not dealing here with malice. So we must be dealing, I suppose, with gross negligence in the administration of justice. And our submission is simply that a fair examination of the record of this case reveals that whatever criticisms may be leveled against the prosecution's handling of the case, there was no such miscarriage of justice. In the end, Mr. Blé Goudé benefited from the full panoply of rights afforded to the defense of any accused under the Rome Statute. The prosecution having failed, in the view of the majority of the trial chamber, to prove his guilt, Mr. Blé Goudé was acquitted of the charges of crimes against humanity that he faced. His rights were equally safeguarded on appeal. In the result, the appeals chamber, by a majority of 3 judges to 2, affirmed his acquittal. Now, in responding to Mr. Blé Goudé's compensation claim, we've organized our arguments around 4 key phases of the judicial proceedings, and those are the point reached by the time of the confirmation hearing, the trial, and notably the no case to answer litigation, Mr. Blé Goudé's release by the appeals chamber on conditions pending the former prosecutor's appeal, and finally the appeal itself against acquittal. And we submit that those 4 moments in the judicial proceedings offer the best opportunity to measure whether or not Mr. Blé Goudé has made his case for compensation. Now, our response to his claim is fully developed in our written submissions. I'm only going to touch on key highlights. I'm also going to leave to our written submissions the position we take on his calculations respecting what he says he's owed in compensation. If we look briefly at the confirmation hearing, this, of course, is the point where the prosecution had completed, or nearly so, its investigation, made disclosure to the defense, and described through the DCC the shape of its case against the suspect. Of course, the prosecution is required to investigate, to determine the truth, and to look for incriminating and exonerating circumstances equally. And to do that, the prosecution has to act in good faith and to take all reasonable steps available to it. And we submit that that's exactly what happened in this case. By the time of the confirmation of charges, the prosecution had not only disclosed its case against Mr. Blé Goudé, but had disclosed to the defense material from its investigation concerning armed opposition elements, variously described as commandants invisibles, forces nouvelles, or rebels, who were active in Abidjan at the relevant time. And this information was pertinent to the defense. It came from many sources, including the range of witnesses the prosecution interviewed, and who gave evidence respecting the post-election violence from their diverse vantage points. It came from extensive archival material that the prosecution reviewed in Côte d'Ivoire. So by the time that the prosecution came to the confirmation hearing, it believed it had understood the context. It had identified the crimes committed during the conflict surrounding the contested presidential election in Côte d'Ivoire, and it had described what it believed was Mr. Blé Goudé's part in those crimes. The prosecution's case theory was based on its assessment of the evidence as a whole, taking into account both incriminating and exonerating aspects. And in presenting its case against him, in the DCC and later in the pretrial brief, the prosecution did not omit mention of factors relevant to the defense. In those circumstances in our submission, it's very hard for Mr. Blé Goudé now to claim that he was subjected to a wrongful prosecution as a result of the prosecution's investigation and presentation of its case theory. Coming briefly to the trial. The arguments that he makes in his compensation claim were arguments that he raised before the trial chamber, which by a majority resolved them in his favor. And in our submission, that's why they really don't belong in this application. And we say that Mr. Blé Goudé, in criticizing the prosecution for failing to establish the authenticity of documentary evidence that it presented, overlooks efforts that the prosecution did make in good faith by examining official markings and formats, by assessing the context in which the documents were found, steps that it described in its investigation reports. This, in our submission, was a fair way to proceed. The prosecution also attempted further to authenticate documents through witnesses at trial, including high-level insider witnesses who did authenticate many of the documents shown to them. These were reasonable steps to take, we submit, particularly in circumstances where information about authorship and chain of custody was no longer available or even obtainable. And this is a situation that is not uncommon in international criminal trials. In addition, reliance on anonymous hearsay is not impermissible, and such evidence is not devoid of value. But the prosecution didn't seek to rely on it alone to prove the material facts against Mr. Blé Goudé. It attempted to use this evidence in support of other evidence in the case. That it ultimately did not succeed in some instances does not mean that the prosecution acted wrongfully or in a manner that gave rise to a grave and manifest miscarriage of justice. We know what impression the prosecution case ultimately made upon the minds of the judges hearing the case. But we do say that the comments made by Judge Henderson, whose views reflected the majority opinion, are telling about the conduct of the prosecution. Speaking from hindsight and offering his criticisms, he said, and you have already had this brought to your attention, although this opinion is at times critical of the prosecutor, it's crucial to understand that this criticism is aimed at the prosecutor's case and not at the individuals who've represented the office of the prosecutor. The fact that this case has ended in an acquittal is due to the fact that the prosecutor did not present us with sufficient evidence to persuade us that a reasonable trial chamber could convict the accused of these specific charges. It may well be that some of us may be of the view that they would have done things differently. However, this in no way impugns the integrity, good faith, and commitment of the women and men who represented the prosecutor in this case, and whose incredibly hard work and great efforts should not be disparaged because it did not lead to a conviction. We submit that such comments undermine the suggestion that Mr. Blé Goudé has been the victim of a miscarriage of justice. The dissenting judge, Judge Herrera-Gabusia, careful to frame her opinion in terms of what a reasonable trial chamber could find in the evidence, took a different view of the prosecution case and the evidence against Mr. Blé Goudé. And you're well aware of the view that she took. As the prosecutor has pointed out, our point is simply this. There was a divergence of views on this case in the trial chamber, and judicial criticism of the case brought by the prosecution, even expressed in strong language in the acquittal judgment, is not determinative of the question whether a grave and manifest miscarriage of justice occurred. Whatever the criticisms here, there can be no suggestion that such a miscarriage happened in this case. Now, Mr. Blé Goudé has, Mr. Knops on his behalf, has placed a great deal of emphasis on the suggestion that the prosecution maintained the narrative of its case unchanged from before the trial opened until after the close of its case. Whatever the merits of such an argument may be, Mr. Blé Goudé has failed to show why this narrative caused him any prejudice or subjected him to a grave and manifest miscarriage of justice. Even if the prosecution at that stage, that is, after the close of its case, continued to put forward what it felt was its best case, it still included in its narrative evidence that was potentially exonerating. Mr. Blé Goudé, we submit, suffered no prejudice here, and this is really what the issue is before the chamber. The prosecution continued to be transparent in its inclusion of those aspects of the evidence that were potentially helpful to the defense in its written submissions to the chamber. And with respect to the timing of the prosecution's statement to the trial chamber that it would not oppose the dismissal of two of the incidents relating to the case against Mr. Blé Goudé, we would submit that in responding to the no case to answer motion was a perfectly legitimate time, a perfectly proper time for the prosecution to make that concession, if you will. A trial is a dynamic process, and the decision to withdraw two of the charges of the five was a product of how the trial had unfolded to that point, and the decision of the prosecution inured to the benefit of Mr. Blé Goudé, and demonstrates that the prosecution was in an adversarial system where it was putting forward its case and the defense could challenge that case, acting responsibly by conceding that the nexus between Mr. Blé Goudé and the two incidents that are referred to, the Abobo incidents in March of 2011, was not made out. In my submission, that really demonstrates that far from what is being claimed by Mr. Knops on behalf of his client, the prosecution acted responsibly and fairly throughout. Let me come briefly to the release on conditions. Mr. Blé Goudé faults the former prosecutor for requesting his conditional release in light of her position about a retrial. In our submission, however, there are three key reasons why his arguments fail to demonstrate a grave and manifest miscarriage of justice. First, in relation to the conditional release that the prosecution requested, Mr. Blé Goudé's rights had judicial safeguards. The appeals chamber imposed conditions of release on Mr. Blé Goudé following hearings. In the first set of hearings in February of 2019, The reasons for judgment had not yet been released, and so the prosecutor was not in a position to be able to say precisely what shape her appeal would take, but she was intending to appeal. If we go forward to May of 2020, when the appeals chamber reviewed its conditional release order, following a hearing on Mr. Gbagbo's request for reconsideration, it unanimously found no error or injustice. Now, in the meantime, of course, there had been another hearing in February of 2020 on the issue of conditional release. But in May of 2020, the appeals chamber unanimously found that there had been no error or injustice in the way in which the then accused had, or at least the then acquitted men had then been treated. Of course, the appeals chamber on its own motion relaxed the conditions pending the outcome of the appeal. And when the appeals chamber, by a majority, ultimately upheld Mr. Blé Goudé's acquittal, all of the release conditions imposed by the court were lifted. So our submission is that Mr. Blé Goudé thus received a fair adjudication of his conditional release throughout the appeal proceedings. Secondly, the former prosecutor's position on conditional release before the appeals chamber, as conveyed through counsel, was both reasonable and transparent. In January and February 2019, as I've said, when she first sought Mr. Blé Goudé's release on conditions, she was not in a position to specify exactly what remedy she would seek, and of course, by that time, the time for appeal had not even begun to run. She was anxious, of course, to preserve her statutory right of appeal and any remedy that she could seek. By February of 2020, of course, the second hearing on release, the trial chamber's written decision, reasons had been released, I should say. The reasons had been released and the appeal had been briefed. And at the hearing, the prosecution confirmed, if successful on appeal, she was seeking the remedy of reversal and mistrial. Now, through counsel, the former prosecutor further explained if this remedy were granted, she intended to retry Mr. Blé Goudé, but her final decision, including on the exact scope of any trial, would depend on the appeal judgment itself, which of course was not yet out, and several other factors affecting the feasibility of a retrial. And we have dealt with those factors in our written response, and I'd refer you primarily to paragraphs 49 to 52. But she also acknowledged the appeals chamber's own power to order a retrial, regardless of the remedy she requested. Now, in the end, of course, the former prosecutor never had to decide. Her appeal was rejected and the acquittal upheld. Our position is simply that the former prosecutor took a reasonable position on conditional release, and she was always transparent with the appeals chamber and with Mr. Blé Goudé about the remedy she sought and its relevance to conditional release. Thirdly, and finally, there are some features of Mr. Blé Goudé's position respecting conditional release which are peculiar to his situation, but which I won't address in open session, and we've dealt with those in paragraphs 46 and 53. To sum up, Mr. Blé Goudé's conditional release pending appeal cannot support an argument in our submission that there is conclusive proof he fell victim to a miscarriage of justice. The final point I can make very briefly relates to the appeal itself. The prosecutor's appeal cannot be described as frivolous. It followed the acquittal entered by the trial chamber at the no case to answer stage of the trial in a 2-to-1 decision where there was a clear dissent. The appeal raised for decision serious issues of law and procedure, namely compliance with the provisions of Article 74(5), and the legal standard of proof test and its proper application to no case to answer motions. Although dismissed by a 3-to-2 majority in the appeals chamber, the appeal, as the prosecutor has pointed out, drew 2 strong dissents. Such an appeal cannot be described as frivolous. Now, Mr. Blé Goudé criticizes the way the former prosecutor framed her appeal on grounds of legal or procedural errors and not on the basis of errors of fact. However, appeals may be brought on the basis of errors of law, of procedure, or of fact, and it was up to the former prosecutor how best to frame her appeal. Two of the appeal judges in dissent would have given effect to the prosecutor's appeal based on the alleged errors of law and procedure and their impact, and would have ordered a new trial. Mr. Blé Goudé also criticizes the appeal based on the approach of the prosecution to the matter of retrial, but I've addressed that issue. Our submission is simply that the appeal offers no comfort to Mr. Blé Goudé and his claim that he is the victim of a grave and manifest miscarriage of justice. Madam President, Your Honors, I'm going to leave it there. In conclusion, none of Mr. Blé Goudé's allegations, taken individually or cumulatively, establish conclusive facts proving a grave and manifest miscarriage of justice. Madam President, Your Honors, for all the reasons we've given, we would ask that Mr. Blé Goudé's claim for compensation under Article 85.3 be denied. Thank you.
Thank you very much, Mr. Representative of the Office of the Prosecutor. That is Mr. Stewart. I will now give the floor to the representative of the Registrar, Mr. Henkens. Am I pronouncing your name well? Absolutely.
Allow me to continue in English, please, Madam President, Your Honours. Insofar as it is helpful, in view of the purpose of this hearing, in open session, what I could submit on behalf of the Registrar is that the Appeals Chamber judgment has been considered and is being implemented by the Registrar. That is to say, insofar as the Registrar was directed, pursuant to Rule 185, para 1 of the Rules of Procedure, to make such arrangements as considered appropriate as soon as possible for the safe transfer of Mr. Blé Goudé to a state or states contemplated in that rule, taking into account the view of the acquitted person. If it is helpful for Your Honours, for the Registry to briefly highlight some of the points we have submitted in our confidential filing, I would respectfully request that we go into private session.
C'est bon?
Madam President.
Very well.
Merci beaucoup.
Thank you very much. Prosecutor, you can answer the question from Honourable Judge Ugalde.
I'll answer just the part of Your Honour's Ugalde's question regarding the drafting. I think the terminology of her was just to, in the filing, referring to my predecessor, was simply a term of art in the drafting to separate the two terms of office. But in terms of the specific question, the prosecutor embodies, in my view, the office. There's a continuity of responsibilities under the Rome Statute, such that on the 15th of June, there was no sunset clause that would give rise to any guillotine effect, and those responsibilities are continuous, of a continuous nature.
With your permission, the question that I'm going to address is...
Vous pouvez y aller, Monsieur Stewart.
You may go ahead, Mr. Stewart.
The question I'm going to address is what conclusive facts must be present to prove a grave and manifest miscarriage of justice. And of course, I suppose in the abstract, Your Honor, I could answer that question by simply saying conclusive facts demonstrating malice or such gross negligence in the administration of justice that the fundamental rights of the accused person are demolished, if I was to answer it very briefly. Dealing with this particular case, and I think Mr. Knops in his answer has tried to come back to the particular case, I suppose that the simple answer for me to give is, whatever we may think in hindsight during the course of the unfolding of the investigation and the prosecution believed in its case. They believed they'd understood the context, and as I said earlier, what had happened around the contested election and Mr. Blé Goudé's part in it. But in forming that view on the whole of the evidence, the prosecution didn't ignore issues or evidence that would be of value to the defense and made disclosure. And in fact, that disclosure assisted the defense to attack the prosecution case, to cross-examine prosecution witnesses. If I could really put it down in a line, as I understand it, the defense was putting a great deal of emphasis on the fact that the government troops were coming under attack in certain neighborhoods in Abidjan, that there were active armed groups, that you're dealing really with, in a sense, a kind of guerrilla warfare, an urban kind of guerrilla warfare. And I suppose from the prosecution perspective, that was accepted, that was the case, that was the context, and these things were in fact happening. But the issue for the prosecution was, did that justify targeting civilians? And the answer from the prosecution's point of view was no. And the case that they tried to put forward was, this is what had happened, that Mr. Blé Goudé had a part in it. In the end, they were unsuccessful. That case, that theory, if you will, was rejected, as the prosecutor himself has accepted, acknowledged, stingingly rejected. But was it entirely unreasonable? And that's why it becomes important to look at the dissenting view. What Judge Herrera Carbucia may have seen was a narrower case than the case that the prosecution had put forward, but she saw a case that called for an answer. Now, in making that argument, Your Honor, I'm not suggesting for an instant that we should try and relitigate the guilt or innocence of Mr. Blé Goudé. He's been found not guilty. We accept that. What we are looking at is, having been the subject of an unsuccessful prosecution, was he the victim of a wrongful prosecution? And in our submission, he was not. In the end, his rights were vindicated. Oh, I'm sorry, if you permit me just another moment. My friend has referred to the February 9th, 2018 order on the conduct of the proceedings. And I think it's important really to see what the Chamber was doing at the time. If you'll indulge me for a moment, I will read paragraph 10 that Mr. Knops has referred to. And this is how it starts out. The Chamber recalls that the defense for Mr. Gbagbo had indicated that for the defense and the Chamber to be able to appreciate and assess the prosecutor's case, in particular in light of the significant number of witnesses withdrawn since the opening of the trial, the prosecutor should provide an amended pretrial brief where all the evidentiary items submitted and the testimonies would be specifically linked to each of the charges. At this stage, in accordance with its statutory powers and responsibilities, and with a view to meeting its obligation to ensure the fairness and expeditiousness of the trial, the Chamber considers it indeed necessary to invite the prosecutor to file a trial brief containing a detailed narrative of her case in light of the testimonies heard and the documentary evidence submitted at trial. More specifically, she should indicate to the Chamber in which way she thinks the evidence supports each of the elements of the different crimes and forms of responsibility charged. And then I won't read it, but in paragraph 14, the defense is given certain instructions as well with respect to how the proceedings were to continue. I submit that what you see there is not really what Mr. Knops is representing. The Chamber is trying to organize the massive evidence in an intelligent way to decide what proceeds and what doesn't proceed in anticipation of what ultimately it did. Thank you.
Merci beaucoup. Monsieur Blé...
Thank you very much. Mr. Blé Goudé, do you have an urgent need? You can go. Very quickly.
Concession.
We'll make this concession to you.
You need to go back into private session for the last question.
En attendant, nous retournons.
While waiting, we'll go back into private. That's it.
We're
C'est
back in
bon?
open session.
Ok.
Your Honours.
Very well. Thank you, Court Officer. I was saying that at this stage of our exchanges, we can say that our hearing of today has now concluded. I don't see anybody having any other issues to bring to bear at the moment. So, as such, we shall adjourn, and the Chamber will take into account all the different information that has been gathering from the start of the proceedings, and it shall take into account the submissions of the parties and all who have taken part in the proceedings, and it will render its decision at the appropriate juncture. So if there is nothing else on the agenda, I now consider that the Chamber can withdraw, and I consider that the case is adjourned and the Chamber shall withdraw. I'd like to thank you for your attention.